Good morning, everyone, and thank you for joining us this morning. Welcome to Aurora & Company Advocates' flagship Fresh Thinking series. For those of you who are joining us for the first time, this is an event that we run once every quarter to update our clients on current legal developments and just generally new market trends. By way of an introduction, my name is Radhika Arora. I'm an associate in the dispute resolution team here at Aurora & Company Advocates. And our practice largely focuses on banking, finance, arbitration, and of relevance to you today, insolvency and restructuring. I will be moderating today's session along with my beautiful colleague, Eva Mukami.
Thank you, Radhika. As she said, my name is Eva Mukami. I'm also an associate in the dispute resolution department here at Aurora & Company Advocates, with a focus mainly on commercial litigation, arbitration, and of course, insolvency and restructuring.
Before we begin today and before Mukami introduces our topic for the day, just a couple of house rules. Firstly, we intend for this webinar to run for about an hour and a half. We've reserved the first 1 hour for a panel discussion and the last half an hour for a Q&A because I'm sure all of you have burning questions. If you do have any question, please feel free to pop it into the Q&A function, which is lighting up at the bottom of your screen at the moment. Secondly, this will be a recorded session, so don't worry about taking notes. Just sit back, relax, and enjoy the discussion that we have lined up for you today. Finally, needless to say, this is a discussion between a couple of people who are practicing in the insolvency field currently. So nothing that is said today should be taken as legal or financial advice, lest our bosses have our head. And welcome, have a good time.
Thank you, Radhika. So, as per the invite for today's session, we are discussing insolvency in Kenya, and we understand that it's quite a broad topic. Therefore, today we propose to only focus on corporate insolvency. In that regard, we won't be dealing with bankruptcy. However, should you have any questions for us later with regard to that topic, you can always reach out to your contact at the firm or at insights@oraro.co.ke, and we'll have someone reach out to you.
So before we get started, we'd like to introduce you to all of our panelists and have them say something about themselves. First up, we have Kamal Shah from Grant Thornton. Kamal is the executive chairman of Grant Thornton, and prior to that, he was a managing director of Grant Thornton Kenya for 20 years. During his tenure as managing partner, Kamal served as the hub leader for Grant Thornton East Africa. He was also responsible for the collaboration between Kenya, Uganda, Ethiopia, as well as the correspondent firms in Tanzania and Rwanda. He has spearheaded the growth of Grant Thornton in this region through collaboration and value addition in shared resources. Kamal is a chartered accountant of India. He's also a certified public accountant of Kenya. He holds a Bachelor of Law degree as well as a Bachelor of Commerce degree, and he was the chairman of the Chartered Accountants of India Institutes, both in India and in Kenya. Kamal has a wide range of experience in the insolvency field, and he's been a receiver, manager, and liquidator for Nyanza Spinning and Weaving, Swan Industries, Red Matches, Red Hill Gardens, Vershi Devchi, Kentex Apparels, Meisner Millers, Lento Agencies, and many other companies. It's just too much of a mouthful. Welcome, Kamal. Please tell us more about yourself, Grant Thornton, and introduce your colleague, Parag.
Thank you, Radhika. Good morning and welcome to Insolvency webinar, part of Fresh Thinking series organized by Aurora & Company, Kenya's leading firm of advocates and an affiliate member of AB and David Africa. My name is Kamal Shah, and I'm grateful to dynamic team of Aurora & Company for inviting me and our firm Grant Thornton to share the podium with eminent experts Emily Drake, Steve Ogada, and partner of Aurora & Company, Noela Lubano. Thank you very much. I take this opportunity to introduce our firm Grant Thornton. Grant Thornton is a global professional services firm providing audit, tax, and advisory services to dynamic organizations in 136 countries. Our purpose is to care for our people, clients, and communities, and helping to create a sustainable impact in the world. We promise to go beyond business as usual to deliver a different experience for our people, clients, and communities. I'm serving Grant Thornton for the last 33 years, and my journey has been truly transformational. As Grant Thornton in Kenya, we are experienced insolvency practitioners practicing since 24 years, and I personally have held position of joint receiver manager and liquidators in more than 10 different companies. I have with me my partner and our firm's advisory practice leader, Mr. Parag Shah, who works with me hand in hand in insolvency practice, and he specializes in financial advisory, corporate finance, business risk services, forensic audits, and other related services. Welcome, Parag.
Thank you, Kamal, and thank you, Aurora and Company, for giving us this opportunity. To introduce myself, I'm the head of advisory at Grant Thornton in Kenya and look after the wider East Africa region as well. My expertise is in two fields, in business risk and corporate finance. So as part of the risk services, we also cover recoveries and receiverships. And I've been working closely with our peer networks within the world, especially the UK, in doing any sort of debt structuring or mergers, valuations, etc. So that's a brief background, and I'll pass it over to you.
Thank you to Kamal and Parag. A warm welcome to you. I have the pleasure of introducing our third panelist. This is Emily Drake, who's a legal director at Gatley Legal. Emily has expertise in asset protection, asset tracing and recovery, and has represented parties in disputes in the High Court and the London Court of International Arbitration. She has also advised clients in cross-border matters involving other jurisdictions, such as the British Virgin Islands, Cyprus, and the CIS market. Emily regularly undertakes contentious insolvency matters with a particular emphasis on tax avoidance, evasion, and fraud. Her experience and expertise also encompasses complex property disputes. Emily also has significant experience in advice of matters, assisting clients to identification and recovery of assets and preparing interim applications for the preservation of assets and documentation. A very warm welcome to you, Emily, and as we say in Swahili, karibu. I'd like to give you this opportunity to tell us more about yourself and Gatley Legal and your role in insolvency.
Thank you very much. Good morning, everyone. I'm delighted to have been asked to speak at this webinar, and I thank you for the opportunity. I am a legal director of Gatley Legal, which is a legal and professional services group who have been providing commercial legal services to businesses and individuals over the past 200 years. We have over 750 professional advisors and employ over 1,100 people across 11 offices in the UK. We also have an office in Dubai. In 2015, we were the first UK commercial law firm to float on the London Stock Exchange alternative investment market. And this has really allowed us to differentiate ourselves from what is a quite crowded legal market in the UK. We've been able to diversify our offering to clients by acquiring complementary business services to run alongside the legal services that we provide. My background, as they were saying, is predominantly in relation to contentious insolvency matters. I've been a solicitor for 16 years. I regularly get involved acting for IPs who are appointed as administrators and liquidators. So I will typically get involved in securing their appointment, be that the administration application or issuing winding up petitions. I'll also assist with their investigations into the assets of the company, also bring claims on their behalf in relation to third parties and management, and also get involved with the distribution of assets to creditors. I also have experience on the other side, so dealing with creditors who are looking to be involved in the insolvency process and dealing with matters such as retention of title. And I think there's quite a good précis that Ava said previously, so I won't say any more, but I'm delighted to be here.
Thank you, Emily, and we're excited to have you. Next, we're going to introduce you to our resident money man of the day, because let's get serious, we're all here to learn how to get our money back. Steve Ogada is a corporate and project finance expert with capital markets experience. His focus areas cover financial modeling and analysis, financial due diligence, financial restructuring, and capital raising. He's worked with entrepreneurs, project developers, and corporates in various sectors, including manufacturing, real estate, energy, and financial services. Steve also has experience in balance sheet restructuring, having worked on assignments, notably with Kenya Power and Uchumi Supermarkets. Most importantly, Steve played a lead role in preparing Kenya's first ever company voluntary arrangement, or CVA as they're called, for Uchumi Supermarkets under our current insolvency regime. He holds a Bachelor of Arts degree in economics from Kenyatta University and is FAST Level 1 certified by the FAST Standard Organization. Steve is also a CFA charter holder and a member of the Institute of Certified Financial Analysts. Welcome, Steve. We're so excited to have a money man in our midst. Please tell us more about yourself, your insolvency experience, and Investia.
Thank you very much, Radhika. I'm humbled. Thank you, Radhika, Eva, Noella. Thank you to Oraro and company for giving us this opportunity to discuss this subject matter. So Steve Ogada is my name, as Radhika has mentioned. I represent a firm called Investia Africa. Investia Africa is a boutique corporate and project finance advisory firm based out of Nairobi. We work with entrepreneurs, project developers, corporates in terms of, we like to say, we help them quantify their decision making, and our services include financial analysis, business valuations, commercial and financial due diligence. We also do capital raising. We also help lenders in terms of IBRs or independent bank reviews. We've done work also in the public sector space in terms of helping governments with respect to the extractives industry, trying to extract value from that, ensuring that public policy is alive to the current economic environment. So in summary, we've worked with various entities in terms of just helping make sense of numbers, mobilize resources, financial modeling, financial analysis. And we are glad to be part of this discussion, and I'm happy to interact with my fellow panelists, and looking forward to a fruitful discussion. Thank you.
Thank you, Steve. A very warm welcome to you. I have the honor of introducing our fifth panelist, our very own Noella Lubano, who's a partner here at Oraro and Company Advocates. She's a recognized dispute resolution and arbitration expert. She also specializes in asset tracing and recovery, commercial litigation, employment and labor law disputes, and shareholder disputes, and is well regarded for her international arbitration and insolvency and restructuring expertise. She has been ranked by leading international directories such as Chambers Global and Legal 500 as one of the leading dispute resolution lawyers in Kenya. Noella was recently recognized as one of Africa's 50 most promising young arbitrators in 2020 by the Association of Young Arbitrators. She has spoken on various topics around international arbitration, such as at the International Arbitration Conference in Kigali in 2017, in Addis Ababa in 2018, and in Nairobi, Kenya in 2019. She has also shared her legal insights across the globe, including in the UK and in Austria. She holds a master's degree from the University of Cape Town, a Bachelor of Law degree from the University of Nairobi, and a diploma in law from the Kenya School of Law. Welcome to you, Noella, and joining us from approximately 5 feet away and in what we fondly call the Einstein boardroom, Karibu Sana.
Thank you so much, Radhika, Eva, for that introduction that I barely recognize it was me, but yeah, it seems it is. So thank you. So just to say welcome to all our viewers, all our panelists. Most of you are our clients, so we are no strangers to each other. Thank you for taking time to join us. We hope that this will be an interactive session for you. For those who are not familiar with Oraro and Company, if you can allow me, I'll say something small about the firm. So Oraro and Company is about 40-plus-year-old firm. And our founding partner, Mr. Oraro, likes to say that it started literally from the street with a table and one chair. And throughout the years, we've obviously grown into what is a Tier 1 firm. We were the largest disputes firm. We're fairly the largest disputes firm currently, among others. We have a full service, we offer a full service portfolio. We have a commercial department, a litigation department, as well as a real estate department, but we focus mainly on commercial disputes. Insofar as I'm concerned, I mainly do advisory on insolvency. I also guide clients through the insolvency processes, be it liquidation, administration, CDAs. We also represent clients in court in insolvency litigation, and our main clients are financial institutions and secured lenders. And we also offer advice on cross-border insolvency issues. Having said that, I think we've had a long introduction, and maybe we should just get right into the thick of things. And so I will hand over the podium back to our able moderators, Radhika and Eva. And karibu sana, everyone. Welcome, welcome.
Thank you, Noella, and thank you once again for trusting Eva and I to run this session today. So we'll get started. As all of you know, a corporate insolvency involves a wide range of players. You have the company, you have the directors, you have creditors, both secured and unsecured, and all of them have differing roles and interests. So Emily, we're going to start with you. Can you perhaps give our audience a bit of insight into the role and interest of a secured creditor dealing with an insolvent entity?
Sure. So creditors, obviously, regardless of whether or not they are secured or unsecured, they're all seeking a return, and their interest will really depend on where they sit within the waterfall distribution. For example, fully secured creditors with fixed and floating charges are typically in a much better position than an unsecured trade creditor. But with most things, you're looking at a deficit of assets, and therefore everybody is running the risk of not receiving a full return. So for a secured lender, they really need to look at the different options that are available to them in order to ensure that they receive as much as possible. And that may well be not a formal insolvency process. It may be a formal restructuring, which I know some of the panelists are going to go on to talk about. But I think that a secured creditor also has the ability to realise its debts without really having to incur all the significant costs of a formal insolvency process. But you often find within these situations that there are senior and junior secured creditors, and for a junior secured creditor, they're going to really need to consider what action they can take independently of a senior creditor. There is likely to be contractual subordination, so any intercreditor deed may prevent them from actually taking any action without the authority of a senior creditor. So there's going to be competing interests. It depends where your security sits. It may sit with a holding company rather than the trading company, and so there are sort of the various things that they need to consider when looking at getting a return for an insolvent entity.
Thank you, Emily. I think just to get the perspective of the company in an insolvency situation, Steve, what in your view would be the role of the company, and that is the directors, management, and maybe potential investors in an insolvency situation?
Thank you, Eva. So the various interests, but then speaking to the various stakeholders you've mentioned. So directors primarily represent shareholders, and the overall objective is to ensure that they can be able to salvage the company, considering what Emily has said about ranking or hierarchy or waterfall, that ideally shareholders then will be ranked last. So they would want to then try to ensure that the company is not liquidated, that the company can be optimized to continue as a going concern. Now, management, on the other hand, while yes, they have an obligation to follow through on what directions they get from the board, but they also have the unenviable task of managing interests across the various stakeholders, from shareholders to creditors to various other parties, and theirs as well is to try and ensure that the business continues as a going concern to the extent where they can be able to balance the interests of the secured lenders and the secured lenders, the unsecured trade creditors, and of course, the shareholders. Now, looking at potential investors are looking for an upside opportunity. As you know, in any case where there's a distressed business, there are parties that will be looking at what opportunity it presents, what opportunity is presented. And of course, then theirs will be their key interest will be to safeguard whatever investment they're putting into that business, look at ways in which they can be able to ring fence their investment such that then there are no claims from any creditor. So of course, then they'll really be thorough on their due diligence on in that particular business. Thank you.
So Steve, I'm just going to stay with you for a moment. We're going to come to the various options that are available when dealing with an insolvent entity later. But from your perspective, what kind of an analysis does a lender normally undertake when trying to determine how they're going to deal with this insolvent entity, or what the best course of action is going forward?
Well, thank you very much, Radhika, for that question. I think over time, lenders have appreciated the role of advisors such as ourselves in terms of giving them an independent bank review to look at what are the various options that they can consider to try and ensure. Of course, for every lender, the objective is to continue to have a good book, not want a situation where they have deteriorating asset quality. And so theirs is to ensure that they can work with their clients or borrowers to continue to service whatever facility that they have. And so I'll speak from a practical perspective in terms of our approach and how then that helps lenders in this situation. And so in terms of analysis, you're looking at various scenario and sensitivity analysis in terms of looking at the terms of the debt, be it tenor, interest rate. What happens if we extend the tenor? Is it more flexible for the borrower in terms of, does it generate a bit more cash for them in terms of the cash flow available for debt service? If then you reduce the cost of funding or the interest rate, does it help them be able to achieve the kind of ratios that the bank is looking at, where at least there's sufficient cash flow to be able to repay the loans? You'd also looking at what then from a holistic perspective, you see, Radhika, at this point in time, you're not only looking at what you can be able to do on the debt side, but you're also looking at what you can be able to do on the equity side. Do we then ask the shareholders to put in additional capital, or do we then ask perhaps a source for a third-party investor? And the overall objective is just to ensure that the balance sheet remains sustainable to be able to service the ongoing obligation for the lender. Thank you.
Thank you, Steve. I think we can also direct the same question to Grant Thornton from an insolvency practitioner's perspective. So again, what would a lender have to undertake what kind of analysis would a lender have to undertake before it decides on the best options with regard to a distressed borrower, and specifically to Parag?
Thank you. So, also in the scenario, businesses are also not being economically doing well, and there has been quite a bit of pushback from the banks, especially where there have been borrowings and defaults despite the moratoriums. So where we have gone in, and a couple of months ago, what we did, it was a pretty much business in existence for more than 30 years, but with the COVID situation and understanding their business, they had been suffering a little bit as far as the repayments were concerned. So what we did with the bank is jointly work with the bank and our client to just make sure that we understand that is there any cost-cutting expenses or any other expenditures we can mitigate just to make sure that they can survive in the interim, how we can possibly reduce salaries of some of the key members of staff, go into some contract manufacturing, etc. We also asked them for some of the debt restructuring where they might not need overdraft facilities, but convert them into long-term loans. Also did some competitor analysis, did some price cuts just to ensure that the products can go out in the market. So hand in hand with the bank, we worked with them for about 6 to 8 months, and successfully we did manage to have them at least pay their interest, got a bit of a breather on the principal payments, and that helped us. And I think by mid of next year, we should be able to at least start making the principal payments. So these are some of the key aspects which we feel that the lenders can work with the clients just to make sure that rather than going into either an administrative process or a liquidation process, if they can work hand in hand with the clients, then there can be solutions for this. Yeah, unless my partner Kamal wants to. Sorry, you're on mute, Kamal.
Yeah, sorry. Yeah. No, Parag, I think you have covered it. But if at all it has to go into the administration, then I think there is it's very important that a clear information is obtained from the lenders for making a decision. And I think the planning for that going into the administration is equally important before we do the execution. But I would like to stay there. Thank you. Over to you, Radhika.
Thank you, Kamal, Steve, and Parag. That was very interesting. Now that we know about the decision-making process that goes into determining how to deal with an insolvent entity, we're going to take a step forward and go to the various options available to secured creditors now when that decision has finally been made. So we're going to turn over to you, Noella. Can you tell us what options are generally available to a secured creditor when dealing with an insolvent entity?
Yes, thanks, Radhika. So maybe before I go into these various options, because I think lenders sometimes feel they have narrow options available to them. And one question that pops up is, why should I have options if I have a security that I can enforce? Why am I having this conversation with this team when I have a security? I'll just go enforce it, and life continues as usual. So let's put this in context. So you have a borrower, let's call this a legacy borrower. So a borrower that has supported the bank or the financial institution for a very long time, has deep relationships, and is a high net worth corporate client. The exposure based on the debt that they've taken is extremely high, that it gives the bank sleepless nights, and they need to start thinking a bit more creatively as opposed to going to enforce the security. They've checked the security, and the security has various issues. It may have defects from a formalistic point of view, signing, stamping, registration, or from a very practical point of view, if it's a debenture, there are no assets behind that debenture. Or they've looked at the debt vis-a-vis the asset, and they have found competing security holders, so they would have to share in that pot. Or they have found that the market at the moment is not good for that asset, so that if they sold it under a forced sale scenario, they would not recoup the majority of the debt that they're trying to recover. So to maximize returns, I think lenders have to think a bit more creatively. And there's a wide spectrum. And I think the thought process should start with, I think, what Steve, Parag, and Kamal talk about, an IBR, to see whether this is a case of restructuring. Because I think restructuring is the first point of call. Can we extend the tenor? Can we cap interest? Those are some of the things that the bank's mindset should be at, rather than go straight into enforcement of the security. Once they've done that analysis, the next port of call is they can consider the other insolvency options, and this includes CVAs. And these are voluntary arrangements, company voluntary arrangements, creditor voluntary arrangements, and where basically the creditors can come together and arrange to see how they can deal with the company's debt. And you also have administration, and then you have at the very far end liquidation. So for today, I just want to talk about three things. I would like to talk about administration, CVAs, and liquidation, because those are the legal formalistic ones. And then always remember, the bank has the option of enforcing the security, but this security has issues. They also have the option of filing a suit for recovery of the debt, just directly go to court. But we know the whole idea is to avoid a long court process. So putting aside those two options and assuming restructuring isn't going very well, let's focus on just these three options that you have available. So if we're looking at administration, this is basically where you appoint someone like Kamal, who's an insolvency practitioner, to come in and take charge of the company. And he has three main objectives. The first objective is to maintain the company as a going concern. And the second one is he will be trying to achieve a better outcome for all creditors. And sometimes this particular objective doesn't stick very well with a lender who is secured, because when he appoints this insolvency practitioner, he's hoping that the insolvency practitioner, the administrator, is going in to achieve the best outcome for that lender. So it comes a bit as a surprise when Kamal goes in, or the insolvency practitioner goes in, and when the secured lender says, you need to achieve this and this, and he says, that doesn't work very well for the creditors as a whole. My duty is to ensure that whatever I do is for the benefit of the creditors as a whole. So the third objective is insolvency practitioners and administrators are supposed to go in and realize the property and then make a distribution. So those are the three sort of objectives that are set out under our Insolvency Act. Now, why would you say opt for administration as opposed to any other insolvency process? So I'll just run down some of the advantages of administration. And the main one is really the moratorium that comes with an administration process that sits for 12 months. And what that does is it freezes all claims from competing creditors, from court cases, from people who are trying to enforce, from people who are trying to distress for rent, so that the company has what you would call room to breathe, room to sit down, room to restructure, think about how it can then settle its debts one by one without being distracted by court cases, creditors that are trying to execute, landlords that are trying to kick it out of the premises. And so that's the main benefit of an administration. It gives a moratorium that sits for 12 months. Also, the other benefit of an administration process is ultimately, if it's run properly, it can save the company, so that the company continues to run as a going concern. There may be a sale of some parts of the company, some units of the company, but you still have a company in existence. It doesn't need to be dissolved. The other advantage is it doesn't interfere with employment contracts and the staff. So that's the beauty of an administration process. You don't need to run a redundancy because the company is dissolving. Now we have to let people go, terminate their contracts. So you have that benefit of you still have your staff, you still have your management, and it continues to run. Some people say the other advantage is an administrator comes in with some level of professionalism, and he acts in the best interests of everyone, really, all the creditors, so that everyone is supposed to come up in a win-win sort of situation. The directors get to keep their company. Creditors get their debt settled in a more systematic way rather than in a competitive way. And so those are the main advantages. So what are the downsides? I think the most obvious downsides, and this has been raised a lot by some of our lenders, is it's lengthy and it's costly. And I think that is true when you speak to Kenya, where, at least in our experience, administrators and insolvency practitioners charge quite a big sum of money, which in retrospect, companies have looked back and said we would have given our staff redundancy packages if we would have gone into liquidation. And that money would have been put to better use. So that's one of the disadvantages. Also, there's a lot of negative publicity because there is a requirement that if you're in administration, you indicate that in all your documentation, and it doesn't help your business to tell people you're in administration and you're still trading. Everyone is like, that's going, dying, a dying entity. I don't want to deal with that entity. So that the negative connotation that comes with the term receivership or administration hurts the business as well. And the other disadvantage, and this is from a director's point of view, is the administrator, quite apart from running and managing the company, would then be entitled to look into the company. And if he does find that it is because of the actions of the directors or the management that the company is in the current state that it is, then he's entitled to bring suits against these directors. It could be for fraudulent trading, wrongful trading, it could be malfeasance. And so companies are very reluctant to introduce an administrator or will resist the introduction of an insolvency practitioner, particularly if they are concerned that the company is where it is because of the way they have run it. So that's administration. And I think it's just important when lenders sit down with their customers that they have this in mind, that your director, your shareholder is thinking along these lines when you mention administration. So the other option is a CVA. And a CVA is basically just a compromise or a scheme of arrangement between the company and its creditors. And it's the directors that come up with this proposal for a CVA, and creditors can also come up with this proposal, and they appoint a supervisor. I think that has changed to a monitor under our Insolvency Act. I'm not sure. It's either supervisor or monitor who then implements the creditors agreement after it has been approved by a majority of the members of each class of creditors. And the classes of creditors usually are split into three. You have your secured creditors, your unsecured creditors, and I forget the third. But all these together then vote on this, the members of the company as well. They all vote on this creditors agreement, which is a compromise or a scheme of arrangement. And usually it will have a standstill agreement where, all the creditors agree to not enforce or demand payment or, for a certain period of time. And then again, just to give the company some breathing room so that then you can run it. Once this creditors arrangement, this voluntary arrangement is approved, it binds the members of the company and it binds the creditors. And the one of the advantages they say that it allows the company to then apply for a moratorium for a period of 30 days, which in the same way gives it room to breathe, room to organize itself, and then room to restructure things and make payments. And then CVAs can take very many forms, and they're more like restructuring agreements. There isn't really a big difference because you can have a CVA that requires maybe a capital injection, that requires a debt to equity swap, that requires a sale of part of the business or all of the business, that requires a merger and acquisition. So, the CVAs can take whatever form, and most of these forms are the same forms that a restructuring arrangement would take. And what are the advantages of this? The advantages are the things that were the disadvantages of an administration. For instance, the directors remain in control of the company, which directors really like. So, they manage their baby, they midwife it back to recovery without the interference of a third person taking control, so to speak. The 30-day moratorium is also something that's very advantageous from a CVA point of view. And then it's generally affordable, more than an administrative process or a liquidation process. And the disadvantage is you don't get an automatic moratorium. You have to apply for it from the court. And then secured creditors can refuse to be bound by the CVA and can still operate outside the CVA and enforce their security if they find that the CVA is not working for them. So from a company perspective, it has that disadvantage. The other thing is if it fails, it can expose the company to breaches of contract if it fails to meet the terms of the CVA. Say, for instance, there were certain milestones that the company was supposed to do. So that's the second one. And then lastly, of course, is liquidation, which I think the attitude of lenders, the attitude of all companies, and everyone really should be that this is a last resort. And I think the Insolvency Act in Kenya seeks to bring that out, that liquidation is a last resort. We're not in the business of cannibalizing companies and, you know, being the death knell and putting them to bed. That's not desirable from a public policy point of view. What is desirable is they remain alive, they remain sustainable. But there are situations where that is the only option. And such a situation is, and when the lender is looking at a company, it's where the directors themselves feel that they would be open to a claim for wrongful trading if they continued to trade. And that is a company that is suitable for liquidation. And also companies that are just insolvent and, you know, don't have assets and their debt, you know, there's no hope of recovery. And so there are various types of liquidation. The one that I'll point out that's a bit different is where you're solvent. And this is where it's a members, you know, voluntary liquidation. It's where you're solvent, it's where the company is just dissolving. And you'd ask, why would a company do this? And it basically is when a company wants to wind down in an orderly way. So it wants to dissolve itself in an orderly way. So it's solvent, it enters into voluntary liquidation. So it files a declaration of solvency where it tells the regulator, that's the official receiver, we are capable of paying all our creditors. And once we do so, we are dissolved as a company. So that's quite different from the other two liquidations, which essentially are driven by creditors and are driven by the company itself. And this is where it's on account of an inability to pay debts. So those are the compulsory ones. And really the effect of a liquidation is it also stops all attachments and executions, they all become void, but it also stops trading of the company. The director's powers are also suspended and the company ceases to carry out as a business. And one of the advantages of this is it removes that responsibility from directors to a professional who is, you know, experienced in dealing with companies that have solvency issues to wind down the company. So all those problems associated with creditors suing you, asking for debts, court cases, all that becomes someone else's problem, and they also freeze all those processes. So that's one of the major advantages of a liquidation. Obviously, employees get terminated, so it's not good in that sense, even though it lifts pressure off the directors and shareholders of the company. And then the business can no longer trade. And then unsecured creditors and creditors are likely to lose money in this kind of venture. And then business reputation of the directors and the company suffers. And so I think, you know, it's just very useful for a lender to have all this in mind when they're considering one option or another. Look at the upsides, the downsides, what is suitable, look at the company, look at the debt, look at the chances of recovery, look at the length of time, and try and see if you can get the best return from the option you pick. And I think that's, I'll stop there, I think.
Thank you, Noella, for that very insightful discussion on the options when to a lender when dealing with a distressed borrower. I'd like to direct the same question to Emily, but this time with regard to a UK perspective and specifically with regard to moratoriums and restructuring.
Sure. So thank you for that, and the very good introduction from Noella about the different options. Obviously, from a UK perspective, the options are almost identical. But the one thing I probably would like to say at this juncture is at the beginning of the COVID pandemic, the UK government actually brought in emergency legislation which gave two new insolvency regimes to the industry in order to try and ease the burdens that were going to obviously come into play as a result of the COVID pandemic. And this was under the Corporate Insolvency and Governance Act 2020. And along with the two new regimes, it also put a temporary pause on the issuing of winding up petitions, landlord actions, and various other bits and pieces. But if I just deal about the two insolvency regimes, one is the Restructuring Plan and the other one is a standalone moratorium. I won't go into huge detail about them, but just sort of a brief overview. The Restructuring Plan is very much like and based upon the schemes of arrangements which I'm sure most people are familiar with. The key differences, I think, for a restructuring plan is in relation to the approval process for it, and also what the courts can actually do. So I think, Noella, you was talking about the approval process for a CVA. It's fairly similar. There is a requirement for 75% of each creditor class to actually approve it, but where it differs is that you don't then need a simple majority of all creditors to approve it. And also the court can actually push through and sanction the plan, even when you have dissenting creditors in a class. So even if you don't actually get to the 75% threshold, the court can still sanction and make everyone be bound by the plan, because they'll look at whether or not the alternatives are actually viable, and also whether or not you've got obstructive creditors who are just trying to force through or become ransom creditors effectively in circumstances where it's not actually for the benefit of the company as a whole. The standalone moratorium is actually quite interesting, because I think it was brought about and it was pushed for by the insolvency industry on the basis that a CVA, one of the big flaws of a CVA was that it didn't give a moratorium. And so this was brought in, but it probably hasn't had the same take up as they were anticipating. And the reason for that is likely to be the temporary pause on winding up petitions. It gave the companies the breathing space that they needed anyway, without having to go into this formal process. But just briefly, what it is effectively a breathing space, but there's no requirement for the company to actually go into either a CVA or an insolvency process at the end of the moratorium period. It is literally, as I say, to give breathing space. It is led by the company and the directors, and they can have a moratorium of up to 40 business days. That can be extended, but past 40 business days, you would need the approval of the court or the consent of creditors to try and effectively rescue a viable business. It's a debtor in possession type process, so the management obviously remain in place, but it is monitored by an insolvency practitioner, and both the directors and the IP are required to effectively certify that the aims of this moratorium is to rescue the business. There are some key qualifications to it. So there are certain debts that still have to be paid during that period. And importantly, it doesn't stop enforcement action by financial creditors, which is mostly obviously commercial lending. So whilst a floating charge holder, for example, cannot crystallize the charge during that period, debts still have to be paid, like commercial lending, rent, the fees of an IP. But those debts are also given a super priority to the extent that actually it goes into an insolvency process after the moratorium comes to an end. It doesn't prevent a secured creditor from accelerating the debt. And if that happens, then the moratorium does have to come to an end, because clearly that debt cannot be serviced by the company, because it will basically be the entirety of the lending at that stage. But the acceleration of the debt won't be a super priority. So I think the thinking behind it is that secured lenders won't actually force acceleration of debt, because it brings about an insolvency process almost immediately. And in those circumstances, they may not have the control that they would have had they considered it from that position. The legislation itself came through very quickly. There wasn't a big consultation process. And so we are expecting tweaks to that legislation in the future. There's also some concern as to whether or not IPs are going to be willing to act as a monitor in circumstances where they have no control over the company or its management, but they are, along with the directors, required to certify that the company is going to be rescued as a result of the moratorium. So it's a bit of watch this space as to whether or not it is something that is really taken up. Obviously, the temporary pause on winding up petitions comes to an end this month. And so therefore we shall see whether or not it is something that is that is taken up and is more prominent, but they're sort of two new pieces that were introduced recently in the UK.
Thank you, Emily. It's really interesting to see how different countries around the world reacted to COVID and how insolvency legislation was molded by the onset of a pandemic, which none of us really saw coming. So Steve, sticking to the same theme, we're going to move to you. We've heard there's various options available, some involving the court, some not, some consensual, some not. In your experience, what financial or economic or other considerations do lenders take into account when determining which of these options they want to pursue?
Thank you, Radhika. So I think, and Noel has outlined the various options. So I think for a lender, perhaps let me just create some context. If you look at the dailies for a long period of time and our local dailies, we've had, we like to call them photo albums of auctions of assets, largely by lenders. Because of distressed borrowers and lenders, of course, are now calling the security. But remember, lenders are in the business of lending money, not liquidating assets. So, for example, largely most of the assets that are being listed are real estate. We all know how real estate market has been. In the past couple of years, it's largely a buyer's market. And so, of course, prices keep being driven downwards because of the glut that is in the market. So from our perspective, I think the key, the number one consideration for a lender is looking at, is there a case for the continued operation of that business as a going concern? Is there still off-take market for whatever goods or services that the business output? Yeah, and if that is the case, then how can the business be optimized to ensure that the lender's facility or loan continues to be serviced? And in that sense, how can they work with management to ensure that the business continues as a going concern? Or even if then one of the options, as Noella mentioned, administration, or even CVA for that matter, how then can they enact or how can they take advantage of that option so that the business continue to operate while at the same time the business is able to generate sufficient cash flow to be able to service the facility. Now, in the unfortunate event that liquidation is considered, then we still have to look at, okay, how does the market demand look like for whatever asset that they're looking to liquidate? We all know that there are businesses for which some assets are so specialized and built for purpose that are not readily tradable in the market. So that is a consideration that, of course, a lender needs to look at. Additionally, we've also participated in advisory where we've guided sale and leaseback options, where the business can be able to sell a certain asset and then lease it back. That way they're able to generate some cash flow in order to offset whatever obligations that they have. But I think the overall objective is to ensure that the lender is able to recover whatever amounts that they are owed, but in a way that that is also advantageous to them from a time perspective, from the economics of it, from the market pricing angle, and also to ensure that they do it in a way that is the most efficient way possible. Thank you.
Thank you, Steve. We've now dealt with the options when dealing with a distressed borrower and the various stakeholders. So now I think we can move on to practical challenges. And I'd like to address my question to Grant Thornton, and that's Kamal and Parag. So what are the practical challenges in your experience when acting as insolvency practitioners in your role as administrators or liquidators?
Thank you, Eva. I think I'm very thankful to Noela that she has made my life very easy by mentioning quite a number of things which we are doing as liquidators and administrator. But I would like to take it more from the practical aspect. I think as Emily mentioned, that it's a waterfall, and there's going to be a deficit of assets over liabilities. So that's one of the biggest challenge which we have to be aware of when we enter in. And secondly, when we go into any sorts of insolvency, we have to remember that though the law is always with us and it empowers us, we are dealing with, end of the day, with the human beings. And when we deal with the human beings, we are dealing with lots of emotions. And I think our first 2 weeks of insolvency is a very, very challenging period for us, where we have to really deal with the shareholders who feel they have lost everything now, right from the goodwill to the assets to the value of in the business. The management is worried about it and about their own security. And at the same time, the staff is also worried about their jobs and their daily living. So we have a very delicate balance to strike between the creditors' requirements, at the same time to manage the stakeholders, which are the shareholders, directors, and management and the employees. So we have to try and understand firstly where the cash flow is going to come from. I think that is the biggest challenge we have in insolvency. I think we have law behind us, we have lawyers with us, but everybody wants fees. We have to generate the cash flow, and that cash flow is something which we have to first look into it. And I think as Steve said, sometimes the friends like Steve can help us to do the sale and lease back to get the funds for us. Also, we have to work with debtors, because when we have the debtors, we have a right to collect those amounts. But debtors also have a cold feet, and they sometimes don't pay us as soon as we want it. So we have challenges on that side of it. The suppliers, they are very wary about the amounts which are due to the company, and they don't want to support us. And we are required to continue with our operations, generate cash flow, and if we are lucky, we have to also make profits. So these are some of the challenges which I see. Sometimes we have also seen that when there is a surprise from the lenders to the shareholders, and they see us as an insolvency practitioner at their doorstep, the first thing they do is they run to the lawyers. And Noela, no offense, but definitely you want to go to the court and try and get an injunction. And the moment we get an injunction, I think the assets deplete so fast that we really find it difficult then to get the the cash flows or the liquidation of the assets with the right value. So these are some of the challenges which we have seen, and we have to then build the confidence of suppliers, build the confidence of the management and the people, and start building the operations up and see if we can. First challenge we have to overcome is to see if we can continue with the operations and generate the cash flow. So these are some of the practical challenges which I have faced in my career as a receiver or as an insolvency practitioner. And I'm sure that when we have to deal with the people, I have practical experience of going with the Securicor or with the G4S with me to serve the notice. So that's kind of a pressure which we go into, and we have seen the employees coming out and they're also opposing the whole action of the banks of appointing the insolvency practitioner. So these are challenges which I find and which I have faced as a practitioner. And we will have to come out. We will have to still find a solution, and we have been able to find the solutions. But I would say for any insolvency practitioner, first 2 weeks are very, very critical. And at that point of time, what type of decisions you make, how you interact with all the stakeholders is very vital to continue in our insolvency. Thank you. Over to you, Eva.
Thank you, Kamal. We'll take no offense to the injunction comment, though Noella, Mukami, and I are all guilty of that. Emily, I'm just going to turn over to you. Maybe can you provide us with your views on any challenges faced by you as a legal advisor when dealing now with a cross-border insolvency?
Sure, thank you. I think obviously with the increasing international elements of business these days, most practitioners find that there are going to be assets and liabilities across many jurisdictions, and the kind of challenges that then face in terms of how they're going to realise those assets, how they're going to deal with those creditors is something that needs to be carefully considered. Obviously, the model law on cross-border insolvency has tried to ensure there's greater cooperation between courts, but the key issue really is the fact that certainly in the UK, and I think for many other jurisdictions, the local courts aren't going to allow the insolvency practitioners to effectively disregard any local laws, and they are going to look to protect creditors in that jurisdiction. So really, you've got to have a look at how you are going to deal with those foreign creditors, how you're going to deal with those foreign assets and liabilities, and things like how they may well be admitted for voting purposes, how they may well be admitted for dividend purposes, bearing in mind the position that they are in as foreign creditors. It is something that is a challenge. I think with assets, you know, there've been a number of cases in which you know, sort of a foreign insolvency practitioner may have got recognition of the insolvency in a jurisdiction and is seeking to have those assets effectively handed over to them for the purposes of distribution, and the courts have blocked that from coming out of the jurisdiction to ensure that those creditors are still protected in that jurisdiction. So I won't go into obviously great detail because we'd be here all day, but effectively it's those kind of things that I think need to be considered at the start of an insolvency where you have got a cross-border element to it.
Thank you, Emily. I think now that we've looked at the practical challenges with regard to insolvency practitioners, maybe we can turn to the legal challenges. And for this question, I'd like to first address Noella to give us a Kenyan perspective. So what are the legal challenges that a lender may face when implementing any of the insolvency processes?
So I think we've mentioned some of them already, but I think the difficulties that a secured lender normally faces is litigation from unsecured lenders and other stakeholders. This can really jeopardize the ability of the secured lender to either realize and recover the debt, whether it's by enforcement of the security or through an administration process or a CBA process. There's a lot of litigation around these processes, and I feel related to that is the lack of understanding of what is a very complex area of law and a very new area of law that doesn't have enough precedent in the form of case law to guide, say, the parties as to which direction is the right direction. And I also think there's a bit of an attitude. The attitude in Kenya is not really to give restructuring a chance. I feel that it is not, let's all come together as creditors and see how we can save this company so that we all benefit from recouping the returns and settling the debts that are owed to us. So I feel that the mindset is very different, and I think it's because we are still a very young country in terms of insolvency. I also feel the legislation has a bit of inconsistencies that need to be cleaned up, which causes quite a bit of confusion. I also think there isn't enough sensitization on what these provisions mean. And it's a really long statute. It runs into 800 sections or about, and I was just telling Emily, it's just the other day that I found tucked in somewhere in section 720 were cross-border provisions on insolvency. And no one reads a statute till section 720. And then there's also contradicting case law on many issues. And I think in time, all these things need to be reconciled. In time, the statute needs to be cleaned up, and cases need to go to the Court of Appeal and the law settled on some of these issues. And lawyers, legal practitioners, financial advisors, banks, financial institutions, insolvency practitioners just need to be better sensitized on how all these moving parts play and fit together as a whole, because the sense is there are very many moving parts. And making sense of them so that you all pull in one direction is really difficult when you have little information, little experience, and no case law to help guide you. So I think from where I sit, that seems to be the biggest problem with insolvency, quite apart from the practical challenges that I think Kamal has set out very properly.
Thank you, Noella. Emily, like Noella said, our insolvency regime is relatively new, only about 5 years old, whereas you have had the benefit of 20 plus years of case law. So from your perspective, what are the legal challenges faced by insolvency practitioners in the UK?
So I would say very much echo really what Noella has said, and I think probably there are two key issues that I think, especially around administration, that seems to be the most controversial, and I think that is born of sort of the ability to have a pre-pack administration that has caused quite a lot of controversy in the UK when it first was permitted. And I think that's kind of where I guess most of our juiciest cases would come from. So I think if it is to be mirrored in Kenya, then particularly you'll be looking at a number of cases dealing with the validity of the actual appointment and whether or not the lender, if they are appointing as a qualifying floating charge holder, they've actually done the correct procedure. They've actually carried it out properly. And we had a slug of cases whereby basically it wasn't followed correctly, and dealing with the fallout of what that actually meant. You had administrators going in and dealing with assets that they had no right to do, and the courts had to effectively fill in the gaps of dealing with what actually happened on those cases. That has largely calmed down now, I think, because most people are acutely aware of how the procedure needs to go, and are doing it properly now, albeit the introduction of the electronic court filing system in the UK has certainly proved a number of challenges on that same issue, because people filing out of hours of court time and whether or not the appointment takes effect at various times, certainly those cases are starting to come through again. But I think that was one of the key issues. I think the other key issue, again, for administration purposes, is where junior lenders or unsecured creditors are looking to disrupt the procedure because they feel their interests are not being adequately protected. And the reason they feel that is because they consider that the IP is too close to the lender. And that's particularly the case for a pre-pack. It's particularly the case if the insolvency practitioner, which is kind of inevitable, has has had an interest in the company, or at least been consulted in relation to the insolvency process. And although it's fair to say that the cases that challenge unfair harm effectively haven't been particularly successful in the UK, what it has shown is that insolvency practitioners do really need to be careful as to how it looks, and sort of not being too close to the lender. I think there are one of the reasons why they're not successful is there are other avenues open to junior creditors if they feel their interests aren't being protected. So, for example, they could force the exit from administration into a liquidation and have their liquidators appointed in order to investigate the previous conduct of the administrators and generally the investigations into the insolvency itself. But where you have practitioners who are seeking to be the liquidators once the administration moves to liquidation, or there is any kind of necessity to investigate the conduct, then that's somewhere that's quite the case law in the UK is there's a lot of very damaging cases to IPs in that regard, and there's no ability to appoint a conflict administrator unless the administrator in office actually consents. You do have that option within a liquidation process, but not within an administration process. So you know, those kind of concerns, I would say, is where battle lines are drawn. I mean, particularly, Noella, if you know your experience in Kenya is that people aren't coming together to try and save the business, then those kind of issues are where creditors are going to start effectively getting into battle with each other if they consider that they're not getting their appointment of an administrator and they perceive some form of conflict in relation to the other one.
Thank you, Emily. Now that we've looked at practical challenges and then also looked at legal challenges, we'd like to move on to lessons from the past, and specifically with regard to issues and practical perspective. And for this question, I'd like to first address Steve. Perhaps we can look at how COVID has shifted the insolvency space and how are things different now in the post-pandemic era to what they were before COVID.
Thank you very much. So COVID has created an unprecedented shock to both businesses and sticking with business in this session, representing different businesses, you've had to then review your budgets. If say you had 2 year, 1 year, 5 year, currently it's more about survival. And then you're looking at if not on a weekly basis, at least on a monthly basis, how you're able to survive, because it's been all about survival. And for businesses, then it's been about how are we able to conserve cash. Now with COVID, curfews, lockdowns have disrupted demand, have affected supply chains, even internationally, and of course has generally affected the level of business. Now that then has an impact on the ability to be able to operate and generate sufficient cash to be able to meet obligations, the debt obligations. So we've found ourselves increasingly working with clients in terms of trying to help them look at avenues to optimize cash and cash conversion cycles in order to meet the obligations as and when they become due. So increasingly, we've seen as a result of COVID, we are getting work for which clients are looking at how they can be able to stay afloat. Additionally, on the lender's side, they've also been more proactive in terms of preempting and managing distress. And again, we've also been engaged with some lenders in terms of trying to address any potential distress in their portfolios, in their asset portfolios. And there's continuous engagement with the clients. And we've seen lenders again being more proactive in terms of offering restructuring opportunities for their borrowers and clients. And so the whole essence of it has been, it is not as has been in the past, where perhaps things spiraled out of control over a period of time. We've seen a situation where within a certain period of time, lenders have been able to then be more proactive in their approach in looking at trying to manage insolvency much better. Clients and businesses have also looked at ways to try and avoid any situation that can lead to distress. Thank you.
Thank you, Steve. Thank you for that. Still sticking to lessons from the past, perhaps, Parag, you can tell us, in your experience as an insolvency practitioner, what are some challenges you faced? What are some problem areas that have arisen, which people don't really talk about, even within the insolvency practitioner field?
So, from past experience, and I think what has been discussed, it's mainly the resistance. And when there is consent from the company itself or the borrowers on the whole entire process, then it makes it much easier and a workable situation with the lenders to work out. See, as also Steve has mentioned, there are many other options now available in terms of mezzanine debt or subordinated debt, trade financing. So at least these alternative sources of debt can help the company stay afloat, and not necessarily that when it's almost insolvent or under administration, it cannot perform its business. So through alternative sources of finance, it can try and seek its credit or secure what it needs to invest in machinery. And basically, this has helped in the past for companies to survive in the interim, and a couple of months down the line, you can always then replace any alternate sources of finance with different lenders or different banks. Yeah.
Thank you, Parag. So now that we've looked at practical challenges, legal challenges, and then also looked at lessons from the past, we are almost at the conclusion of our panel discussion, and I'd just like to give the panelists 20 seconds each for a parting shot. And for the parting shot, if you could just say one thing to a lender faced with a distressed borrower, what would it be? And I'll start with Emily.
Well, I guess following on from what I was saying last is making sure that you've got all your ducks in a row, make sure that you've perfected your security, make sure your documents are watertight, and you follow the right procedure for any appointment. I guess that would be the mainstay for me.
Noella, what about you? If there's one thing you could say to a secured creditor?
So I think we need to think differently, and two things come to mind: lender leadership and cooperation among all the stakeholders. And I think this is very important for you to get an outcome that is good for everyone. And if we didn't think about outcomes that is good for just one creditor, and we applied all this, and just to give an example, if we're going to enter into a CVA, the lenders support can be conditional on directors and shareholders injection of capital. So it's everyone pulling together, whether it's an administration, whether it's whatever it is. I think we all need to work together to get the best result, and our attitudes just need to change to reflect that. So I think that would be my parting shot.
Thank you, Noella. I would like to hear now from Grant Thornton and maybe Kamal or Parag. What's the one thing you'd say to a lender?
Parag, would you like to go first?
So basically what I would address is that between the lender and the borrower, if there is open discussions on how to make the business survivable, and if it is an effective business, there are competing trends and we can see that there is light at the end of the tunnel. I feel that between both the borrower and the lender, they should work hand in hand together, and we have seen businesses trail through these options. Over to you, Kamal.
Thanks. So I think from my side also, I would like to say the same thing, that let's try to understand your borrower better, maintain a close connection with them, and work with them to arrive at a solution before considering the appointment of an insolvency practitioner. Though I'm eating myself, but I have to say what is right, and to start the insolvency procedure. So communication should be the key aspect between the lender and the borrower, and keep a close eye on the management of the company. That's very important. Thank you.
So Steve, we started with the money and we're going to end with the money. What's one thing you would say to secured creditors?
Thank you, Radka. I think at the risk of belaboring the point, I think lenders need to change their approach in terms of just being more holistic in terms of looking at what situation a business finds themselves in. I don't think it's the time in the event of distress is the time to start pulling out your legalese in terms of how secured you are and how then you can be able to enforce. I think, and why I say that is because while yes, you can be as secured as possible and you want to enforce, but the market and the economics of it may not allow you to do so. So as my colleagues have mentioned that they need to be more engaging, additionally more proactive in terms of looking at their client portfolios, working with the clients. I think Kamal and Parag mentioned it, working with their clients in terms of looking at what are the ways to ensure that they can be able to avoid distress as much as possible, so that at the end of the day, it's a win-win. I recall in the CVA that we participated in, it was a delicate balancing act in terms of ensuring that all stakeholders are taken care of. And there was also, even within the secured creditors category, we have, and I don't want to mention names, but we had a situation where some felt that they had that they were more entitled than others, which then led to court cases. And basically, those are the things that I'm saying. You don't want to end up in that situation. So look at what is the most practical, the most practical solution that you can be able to achieve. Additionally, look at it holistically in terms of how perhaps you can also get an advisor to help you with perhaps getting some equity capital into the business, how they can be able to convert some of the assets into cash to be able to prop up the balance sheet so that there's a long-term sustainability of the business. Thank you.
Thank you, Steve. So now we've come to the end of our panel discussion session, and we'll be moving on to the question and answer session. However, we note that our discussion went a bit over time, so we'll only take a limited amount of questions. We had received a question from Mr. Kibe on email, and he asked, if a company is in the middle of litigation, can it still apply to be placed under voluntary insolvency? And if so, what are the effects of any pending litigation? I think maybe we can have Amelie answer this question.
Sure, thank you very much. Obviously, litigation is not a bar to entering into insolvency or solvency. I mean, we said voluntary liquidation. It's not clear whether or not that's members or creditors voluntary. The one thing I would say is obviously directors are always required to consider what's best for the company if there is an insolvency situation, and if they need to go into creditors voluntary liquidation, then you know, the litigation shouldn't really come into it. I think where you've got a members voluntary liquidation, there's going to be an issue if you are a defendant in that litigation as to whether or not the directors can actually declare the statutory solvency. That's going to be required depending on, I guess, what the nature of the litigation is. So I think that's something that needs to be considered. I mean, we do find that liquidation is used as a tool to bring about a premature end to litigation. It's not unheard of. So it can be used as a tool, but really in insolvency in itself is something to obviously consider at all stages. And the fact that you're in litigation shouldn't necessarily affect that as such.
Thank you, Emily. And our next question, which is still from Mr. Kibe, and I think I'll direct it to Noella because it's quite legal, is can the directors and shareholders of a company be personally liable for the debt of a limited liability company if it is placed under insolvency?
Yeah, so I think I'd alluded to this before, and really the liability that arises when a company goes into liquidation is and this would be instituted by the administrator or insolvency practitioner who takes up that role, would be malfeasance, maybe wrongful trading or fraudulent trading. And what this is simply that the administrator has looked at the company and realized that the directors continued to trade in the company when they were aware that there was no prospect of the company paying the debts that it was incurring. So there is some limited scope of the directors being asked to contribute to the debt that the company has incurred in their personal capacity. And there is scope for contributories also to be asked to contribute to that debt in certain limited circumstances. But the short answer is yes, there are certain instances where that is possible.
Thank you, Nola. We'll take another question from the chat box. And the question is, can security only be given and enforced by local lenders? Can offshore or foreign lenders enforce a security? Maybe we'll have Emily deal with this. So can security only be given and enforced by local lenders? And can offshore or foreign lenders enforce a security?
So I can't say I know specifically the procedure in Kenya, but certainly in the UK, we do have people who take security. It needs to be registered and things like that. So I don't think that there's any particular bar. It's not only a local lender that can take security over assets. And so, yeah, that would be the short answer. I don't know if Noella, you've got anything specific you want to say in relation to the Kenyan position.
I think the Kenyan position is pretty similar. So the ability to enforce a security is not dependent on the nationality of the person enforcing it or the person that has been given that security or in whose favor that security was given.
So we'll take another question, maybe switching away from the legal questions now. We have a question from Judah, and I will direct this towards Steve. It is, do we have a standard checklist on what lenders will look for before putting money into a venture to avoid any such risk that can result in insolvency? So any standard checklist by lenders?
Well, so of course, each lender has their own criteria for approving facilities, but of course, the simplest or the two top factors they look at, number one is ability to pay, and number two is collateral. But behind all that is that they're looking at, in as much as there could be ability to pay, but what kind of business, what's the enterprise, what business is it in, what is the sector, what are the industry trends. In fact, we've seen lenders being more specialized nowadays. For example, we have experience in power and infrastructure, and we've worked with the lenders in terms of helping them perform due diligence on projects, just to ensure that they can be able to understand where the risks are, what to do, what not to do, so as to safeguard their investments. So I would say, perhaps in a summary, that different checklists for different lenders. Some are more onerous than others, but most importantly, lenders are getting involved in terms of understanding the industry and the business that they are lending money to. Thanks.
Thank you, Steve. We can take another question from the chat box. We have Jeremiah asking, what options or avenues are there for unsecured lenders to recover their investments in the case of a company going into administration? I think we can have Kamal.
Thank you for the question. I feel it's more legal. If you don't mind, I had to pass it on, but I would like to go in that. But I think the Jeremiah should get the right answer. So Noella, if you can kindly respond to that.
Yeah, sure. Sadly, very limited options. So in what you call the waterfall of ranking of debts, unsecured creditors fall at the bottom, just right before directors and shareholders. And by the time the secured, okay, so maybe just to give you some perspective, you'll start with the administrator's costs and expenses. So he pays himself. So Kamal here pays himself. And then after that, he pays my costs as well, because maybe I'll fit them in there because I'm advising him. No, I'm joking. So let me be serious about this. So you start with the costs of the administration, and then you go into employee liabilities up to, I think, 4 months under the Kenyan statute, which is their salaries and terminal benefits. That's in a liquidation. And then after that, you go into taxes, and then you go into secured creditors, and then preferential creditors, and secured creditors right at the bottom there with members, shareholders. So the reality is you would advise an unsecured creditor to write it off as a debt or vote for a CVA or for the company to continue as a going concern, because then there is some prospect of the company paying them back if it continues as a going concern. But where the company goes into liquidation, because of that ranking, it is unlikely that an unsecured creditor will get anything, because remember, the company is insolvent. There's a reason it's insolvent, which means it doesn't have enough to pay all its debts and all its liabilities. So since you're an unsecured creditor, you fall at the very bottom. And if the company doesn't have money, obviously you're unlikely to get any money. So I think sadly, very little, but also from a strategic point of view, it's very important that unsecured creditors participate in creditors' meetings so that they vote for proposals that are favorable to them. And some of these proposals include, look, the administrator can pay you going forward for continued supply, but cannot pay your debts going backwards. And that's still useful to a supplier who's an unsecured creditor that has already ordered goods based on projections of supplying this particular company that's now in administration. So I think you need to participate in those meetings so that you have a say. Yes, I don't know if that answers that question.
It does. Thank you. Thank you, Noella. We'll take one last question just because we're running out of time. So the question is from Stella, and I'm going to leave it open to our panelists, anyone that wants to answer. It's, should the banks or lenders organize continuous management courses for the borrowers to ensure that the projects or companies they have funded are properly run, or does the bank's duty just end at lending the funds? So I know this is a controversial topic, so I'll leave it open to all of our panelists, whoever wants to answer.
I will go because I passed.
Go on, come on.
I think I can safely say I'm not answering that question.
Kamal, go on.
No, as I said in my parting shot, it is important for the lenders to work with the borrowers, and this is the one way to work together and be aware. And as I said, management is the key in running of an organization. So whether we call it a formal training or we call it a value addition to the clients, it can be taken as a good idea, but cannot be made compulsory. But it's a good idea. Thank you. Yeah, Steve, you can add on.
Yeah, Kamal, thank you. So I think the bank's core business is lending, and so they really need to specialize on that. But additionally, the result should be quality of assets, and quality of assets can mainly be achieved at the entry point. By the time they decide to lend to a business, they've conducted sufficient DD to ensure that yes, there's a case for that business, that the business has offtake, which will generate cash flow, which will be used to service the facility. But additionally, that they're confident in the team the team or management that runs that particular business, they have experience, that the team has sufficient experience to be able to run that particular business, to ensure that as they extract value, then the facility is also being serviced. I think that is very critical in terms of as at the time that a loan is being approved, that they have sufficient confidence in the team in terms of being able to run the business. But let's not walk away from Kamal's point about the collaboration aspects, that in the event the business is experiencing challenges, that's not the time to show who has the pants in that relationship. That's a time to sit down with the business, with the management, and see how can we resolve to ensure that it's win-win. The business continue to operate, but additionally, our facility is performing. Thank you.
Thank you to all the panelists. I see we have one final question on the chat box. This asks, please share the hierarchy of payouts. I believe you can get that in the 4th schedule of the Insolvency Act. You'll find a hierarchy of all the order of payouts. And with that, we propose to close. I'd like to thank the panelists for taking the time and for the insightful comments and the really useful discussion. Honestly, I have learned so much from all of you. Thank you. Thank you again. And I'd also like to thank the attendees. Thank you for taking your time. Thank you for registering. We look forward to seeing you at our next Fresh Thinking series. Please be on the lookout for that. And if you have any other further questions, you can reach out to your contact at the firm, or you can email us at insights@oraro.co.ke and we'll have someone reach out to you, or you can even reach out to the panelists directly. Thank you again, and we wish you a nice afternoon.
Thank you. Thank you, everyone.
Thank you.